Number 9, Mario Fernandez-Saldana.
Good morning, Mayor.
Good morning.
My name is Jesse Dreiser. I represent Mr. Fernandez. I'm here with my co-counsel, Mr. Hill, and lead death penalty counsel, Mr. Tassoni. From a housekeeping perspective, we also, given the next point issues, we brought the state this morning a 10 terabyte external drive so that they could download as much as 10 terabytes of data that they can onto that hard drive so that we don't need to use next point anymore. We have downloaded some discovery, so it's not as if we've been in a total standstill since the filing of our motion, which shut down next point. But I don't know how long that will take for them to get everything uploaded onto that, but I assume in short order. In addition, they did hand us a thumb drive of ATF records this morning, which we haven't reviewed, but it was given to us prior to court this morning. And then in addition, I believe there's a number of terabytes of poll camera footage that was downloaded onto an external hard drive that I believe, if I understood the state correctly, took like a month to download onto this external. So it was handed to Mr. Baez and myself and both of our teams, and with the idea of review it, trade it off, figure out a way to download it. And Mr. Baez and I agreed that we would do that. I have it in my possession now, and I'll try to figure out a way to get him a copy or just hand that over to him in short whenever we've had a chance to review it.
Okay. And then the defense has, on Mr. Fernandez's behalf, filed a motion to disqualify the 4th Judicial Circuit, Office of the State Attorney, related to some matters on that next point, correct?
Yes, ma'am, we have.
All right.
We've
and then
received the state's response as well.
the state has recently filed, which this court has reviewed, the defense motion in addition to the state's response to that motion. And if you all, my understanding is there is an agreement related to a number of the emails that the state is conceding that would be attorney-client privilege.
Yes, Your Honor. In our written response and conversations with Mr. Dreiser and Your Honor in chambers, there are emails he's referenced. We concede those are attorney-client privileged emails. The state has not reviewed them. Law enforcement has not reviewed them. I provided Mr. Dreiser this morning with reports from Next Point showing that those emails were never read, opened, or accessed by anyone from the state attorney's office or law enforcement. Additionally, I provided him a report from the Jacksonville Sheriff's Office Computer Forensics Investigation Unit. They did a forensic examination of the Jacksonville Beach Police Department computer. That report also indicates that the email folder that contains those privileged documents was never opened, accessed, or read by anyone in law enforcement or the state attorney's office. We can see they're privileged. Our position is we did not read them.
All right. But there's one contested document, correct? Or one contested document that the defense is saying it was attached to an email, correct?
Yes, but to respond, they may have provided that information to us this morning. We haven't reviewed any of that. Those emails that they concede are attorney-client privilege were uploaded to Next Point by the state's own admission. They have been able to be accessed at a minimum by anyone at Next Point, by law enforcement, and by the state attorney's office. I'm not prepared to respond today as to whether anyone saw it or didn't see it. I don't know that. But to answer your question, one document that they intend on using, that they've read and they've reviewed, and the court and defense and the state discussed in chambers this morning, and I think that's what is really the crux of what the next step is going to be, Your Honor.
Okay. So you're going to take time to review what they've given you this morning?
Yes, and then I would like to come back in short order, perhaps next week, and respond to what we discussed previously as to whether or not an independent or neutral magistrate appointed by the chief judge should have a hearing as to whether the one document they do intend on using is a privileged and work product communication.
Okay. And so, and just for the record, I want to put this court's reasoning on the record. So the court offered, and Mr. Fernandez, you should know, okay, that this court takes the privilege that you have between your attorneys extremely seriously, all right? That is a veil that cannot ever be lifted unless and until you decide, okay? So this is the offer that I have told both the state and your lawyers, and I'm telling you directly that the offer from this court is a layered approach to shield this court from any information that I am not entitled to. So the offer to your attorneys is for this court to refer just the in-camera review of the contested information / documents. My understanding is the state is conceding a number of those. However, there's one document that I have no knowledge of, okay? I can keep it that way by having the chief judge appoint a independent circuit judge to conduct the in-camera hearing the way in which that judge would see fit. I would get an order based on that hearing from that court, and I would conduct the hearing of the disqualification, accepting the findings of whether that is in fact attorney-client privilege or not, without this court receiving the information that is contained within that document. Therefore, shielding this court from any potential of information that I'm not entitled to. Okay, so you can hear it directly from me. Your attorneys will discuss it with you further. And based on, I guess, the new information that's been provided to you this morning, additionally, maybe it changes your position, maybe it doesn't. And then you all can talk about it, whether the defense feels comfortable agreeing that I would just conduct the hearing on the disqualification without the in-camera review, or if you're requesting an in-camera review, that would be this court's course of action, essentially, like if you wanted to have someone independent. Does that make sense?
Yes, ma'am. Which very may well be dispositive as to whether the second, your hearing of disqualification would even take place, depending on what the independent circuit court judge found. I mean, I can see.
I don't think it dispenses with the issue that you brought, because it's an access issue at that point in time. I could conduct that portion without getting into the substance, in which I want to avoid getting into the substance of something I may or may not be able to, but I think the issues raised, it has to be of record, it has to be litigated, because you're asking for that remedy. The 66 emails, I don't think that one document necessarily is dispositive of the hearing that I would conduct, is my understanding, because you all are still alleging that it's uploaded into some cloud. So what I'm trying to resolve is what you all can't agree on without me having access to information that I'm not entitled to.
Understood.
All right, so I will see you all back December 11th, 9 a.m. for pretrial. That'll give both sides time to review / talk, see if it changes any position on either side. And you can let me know where you want to go from there. And
Yes, Your Honor. That's all we have today. May we be excused?
yes.
Thank you. Have a
All
nice
right, see
weekend.
you Monday. Well, next Monday.
Yes, ma'am.
Thank you.
Thank you, Your Honor.
Thank you.